the case before us from Shawnee County, case number 129054, Kansas Highway Patrol appellee versus Justin Dobler, appellant. Would the parties please state their appearances?
Alan Johnson, and I'm here for the appellant, Mr. Dobler.
Yeah, please court David R. Cooper, Crystal Moe, and KHP General Counsel Luther Gagne for the Highway Patrol.
All right. Mr. Johnson, would you like to reserve any time for rebuttal?
Yes, I'd like to reserve 5 minutes. 5
minutes are granted, and with that, you may begin.
As the court knows from reading the briefs, this is an appeal or a review from a district court decision from Shawnee County, reversing a decision by the Civil Service Board, which had decided to reinstate Mr. Dobler to his employment with the Highway Patrol after he had served a 1-year suspension with no pay. Now, the main issue I want to focus on today is the fact that in reaching that decision, the district court took judicial notice of 16 facts that were not contained in the agency record. And it's my contention that the district court erred in considering those 16 facts, and that this court, under its scope of review, which is the same as a district court, should not consider those 16 facts. And I want to briefly—
Johnson, let me talk a little bit about standard of review. As you and Mr. Cooper both know, we're really bound by the standard of review. And I think you just said the appropriate standard of review, but I just want to make it clear. We're really reviewing the Civil Service Board's final order and not necessarily the district court's order, because our review is the same as if it was appealed directly to us. Is that accurate?
Yes, I agree with that. And towards that end, the 16 facts that the district court relied on are not in the agency record. And therefore, my position is the court should not consider any of those facts because they all related to the State versus Klein case and to a wrongful death case, both of which arose long after the Civil Service Board hearing. They didn't rely upon that. It wasn't even before them. Many of the facts didn't exist at that point, and therefore those facts should not be considered. I agree with you, Judge, that you should look at the record of the Civil Service Board. You're reviewing their opinion. They had a very long, lengthy opinion with many findings of fact, and the real question is, are those findings of fact that the Civil Service Board made supported by substantial competent evidence? And is their opinion reasonable? And my position is yes.
Counsel, just coming back to that, because this is, as you pointed out in your introduction, this is an interesting case because it's an appeal of an appeal of an appeal of a decision. So are we ultimately reviewing the Kansas Highway Patrol's decision, or are we reviewing the Civil Service Board's review of the KHP's decision? What are we reviewing?
You are reviewing the Civil Service Board's decision. The Civil Service Board is a little bit different than many agencies in that once an appeal is made to the Civil Service Board, they become what's called the appointing authority. They're the ones who decide what discipline should be meted out to an employee. And
their review is limited.
They have very broad power to make decisions on. They can substitute their decision for an agency.
Did the Supreme Court in Denning say that review is actually a reasonableness determination? It's not an unlimited determination.
Well,
they can only review and reverse and change the agency's, the originating agency's determination if that determination was unreasonable.
Correct. And that's what the Civil Service Board found. They found it was unreasonable based upon their view of what the discipline should have been. They raised some issues about the decision-making process by the Highway Patrol. They thought that some of the decision-making was suspect, and they thought that overall that the penalty of dismissal was too severe and that a more appropriate remedy, which they're able to do, was to suspend him without pay for 1 year.
Do you agree that Denning, even though I know it wouldn't be necessarily binding on this case, that it's persuasive to us just based on the language in the decision that relates this. That was a county sheriff's case, if I remember right.
Yeah.
But I think the standard would be the same. At least that would be your position.
Yes, yeah. I think the standard is, what was the decision by the Civil Service Board reasonable? And was it supported by substantial competent evidence? But
I bring that up because as I'm sure you can tell, the standard of review is everything in this case, right? And so in looking at who is the decision maker, to what extent, where, and often when we are talking about a reasonableness assessment, we are saying, we're not substituting our judgment for what should have happened. We're just saying, was that decision one that was not unreasonable, right? And so is this different? Is this assessment that the Civil Service Board doing, or that the CSB did, is that a different assessment than our normal reasonableness review?
no, not from looking at what the Civil Service Board did. I think it's the same and normal view. Now, the Civil Service Board, though, in looking in overseeing, deciding what the agency did, they have the right under the statute to modify or change whatever that decision is. As I said, essentially, they are the appointing authority. Then the question for you and for the district court is, okay, well, did they have a reasonable decision? Is it supported by the substantial competent evidence? Is it reasonable, or was it arbitrary and capricious? And I submit that it was reasonable in that they carefully went through all of the evidence. It's a 19-page opinion, I think, single-spaced. They analyzed a variety of things. It was not an easy case, but they were very careful in going through that. And I think this is a close case. The Civil Service Board split 3-2, and they disagreed with what the Highway Patrol did. So again, I think that neither the district court nor you should substitute your judgment for what the Civil Service Board decided, because under the statutes, the legislature said, we want the Civil Service Board to be making those decisions where the employees are classified employees and have rights to employment. And so that is different than their review is different than you. I agree with you. Your review is, was it reasonable, supported by evidence, or was it arbitrary and capricious? And I don't think that you can say that it was not supported by substantial competent evidence, because they went through in great detail what the testimony was. They had 3 days of hearing in which they heard a number of witnesses. They assessed those witnesses. They decided that some punishment should be meted out to Mr. Dobler, but that dismissal was an unreasonable discipline for them. And that's really what you have to decide. Did the Civil Service Board's decision to modify what the Highway Patrol did, was that a reasonable decision to modify that?
So I want to make sure I understand. It seems like both sides agree that there was at least some, you're not challenging that there was at least some violation. I'm sure your client may personally challenge it, but here in this appeal, you're not challenging. You're basically asking us to reinstate the Civil Service Board's order.
Right.
So both sides at least then would agree that there was some type of policy violation, at least for the purposes of our appeal. And it really comes down then to whether or not the Civil Service Board could replace its judgment for that of the Highway Patrol when it comes to the remedy.
Right.
And I know there's language in the statute that says that they can modify. What's that mean?
I think if this court interpreted that gives them very broad powers to modify a decision, employment decision, to what they think is reasonable and appropriate under the circumstances.
If we're reviewing it like they did, can we modify?
No, you have a more strict. Yours is just asking, is it reasonable, supported by substantial competent evidence.
So did you find any cases out there, and Mr. Cooper, I'll probably ask you the same thing. Did you find any cases that would help us understand what modified means? You know, to me, modify means just kind of let's change a little bit. But this seems to be almost of, hey, we recognize your judgment. We don't like that. We're going to just do something entirely different. Have you found any cases that help us understand?
Well, the one
Just
case,
use plain language.
one case I cited was a decision by this court in which you said the power was very broad. Didn't really delineate more than what it was, but broad powers would indicate, I contend, that you can modify, and it's not simply just affirming or reversing, it is modifying, which is the language that is used in the statute. And that means
What needs to be found in order to modify?
an unreasonable decision by the agency.
And is an unreasonable decision a decision with which you disagree? Or does it have to meet some higher standard?
Well, in this case, I think the Civil Service Board, because they are the appointing authority, once the appeal is made to the Civil Service Board, the appointing authority is not the agency, it's them, and they have the right essentially to make a decision on what the appropriate discipline is.
And I think, you can see where our difficulty is here. If under Denning, that review is a reasonableness determination, what does that, because that seems like a narrow view.
Right.
Like a reasonableness determination, that was Kansas Highway Patrol's decision reasonable or unreasonable? And the CSB agrees, or at least accepts the facts that were found with regard to the violation. They just disagree with the ultimate outcome. Is that a reasonableness determination, or is that just substituting the CSB's judgment for that of the Kansas Highway Patrol?
Well, to some extent they can. Again, I go back to the term modify. I think they can in some ways substitute their judgment because they are the appointing authority. And so the question becomes, under all the circumstances, is do they find that the Highway Patrol was not reasonable? And I think they did. It was not, like I said, it was a very well-reasoned decision and justified. And so you would have to find that that was an unreasonable, or was not supported by substantial confident evidence, or was arbitrary and capricious.
Or it was taken in, or it was a decision that was reached that was beyond the scope of that review.
Correct. You could find that, yes. And the remedy would be, if you said, well, Civil Service Board, you went too far, would be to remand it back to the Civil Service Board with whatever instructions you think should be given to them, because in the first instance, they are entitled to make a decision based upon what ultimately you decide they should or should not do.
Council, I think that we have
We've helped you exhaust your time.
right. But you have reserved 5 minutes for rebuttal, and we will look forward to hearing from you unless there are other questions from the panel. All right.
Okay, thank you.
Council, this is a fascinating case.
I don't disagree with you. There are fingers that extend well beyond the bounds of this decision. To address your first question, yes, this is a review of a review of a review, a decision made by the Highway Patrol. And we start with that it was the burden of the appellant, Justin Dobler, before the Civil Service Board to bear the burden of showing his termination was unreasonable. Now, I also agree that the Civil Service Board made the finding, it's in the black and white, they said termination was unreasonable, but they don't tether that to any facts. And on page 31 of the KHP's brief, we use the dictionary terms of unreasonable. It's like, all right, so how did the CSB conclude that the Highway Patrol's decision to terminate Justin Dobler did not reflect good judgment, was irrational, capricious, or an unreasonable decision?
Council, reading between the lines, it looks as though the CSB was troubled by the fact that there was this policy, but there was a conflicting potential policy from this Operation Frontier Justice, and so it looked as though they thought it was less black and white than the KHP perhaps found.
And I think they found shades of gray where there aren't any, and that's okay. In terms of the messiness, again, don't disagree with that. This is messy from the beginning. Justin Dobler I mean, when you get way down in there, started working for the Shawnee County Sheriff when Herman Jones was the Shawnee County Sheriff. He had problems with pursuits then, and while under the shades of a grieving discipline related to a pursuit, he took employment with the Highway Patrol long before Herman Jones became the colonel. He has a problem with pursuits in the Highway Patrol. He eventually gets told, stop getting into chases in Topeka. And that's the issue that the civil board found conflicting in terms of he had been told, quit getting into chases in Topeka, but he was then assigned to the Frontier Justice Marshal's task force, which suggested maybe that order does not apply to him, but the command in that is you are still subject to your agency policies. That gets us back to the black and white and not the gray, which is the agency policy, which is what the Civil Service Board agreed that Mr. Dobler violated OPS 16. He violated the pursuit policy. And the one finding that the CSB did not sustain was the finding that he had violated the direct order. But he did violate OPS 17. He did kill somebody. Those are facts. And we'll need to address the judicial notice of some of those facts. But the CSB found his term.
Well, do we? If our review is of this final order, what difference does it make with I love district court judges. I know Judge Schroeder does as well. But
I also love district court.
good. But what difference does it make? We don't give any weight till that decision. Don't we go back to the CSB's order?
Short answer is yes, and it doesn't matter.
That's my thought. So here's what I think, and everybody agrees there's a violation. At least one. Now, maybe Mr. Or Officer Dobler would disagree personally, but as far as this appeal, we have to, agency policy OPS-016 was violated. So we have to start with that premise. And it looks like the only thing that's really in question is whether or not the KHP's decision to terminate was reasonable or not.
Agreed. And against that background, against that decision, and that's why I talk about the judicial notice of all of those things. The judicial notice really isn't a judicial notice of any new facts whatsoever, but rather it's shining a really bright light on what the impact and the conclusion you must draw from these facts really is, which is the facts were already in front of the Civil Service Board, and they agreed with them, and they found Justin Dobler violated OPS 16. He killed somebody in the process of doing it. When presented with his proposed termination, his response to that was, "I didn't do anything wrong." And then he doubled down on that when he took the oath and testified in front of the Civil Service Board and said, not only I didn't do anything wrong, but if I had it to do over again, I'd do the same thing. So knowing what already happened and presented an opportunity to do a mea culpa, he says, if I had to kill an innocent person again, I'd do it. And I'd like you to give me a patrol car so I can do it again. That was the decision faced by the Highway Patrol. And presented with his response to what do you think we ought to do about the fact you violated these rules? His answer was, I'm going to go do it again. Well, when you're presented with a decision with somebody who says, I'd like you to give me the tools to go commit constitutional violations, the only decision that the command staff could make is, then you don't need to work for the Highway Patrol anymore.
What about Mr. Johnson's argument? And it is based on the statute that says that one of the remedies that the Civil Service Board has is to modify.
I agree with that too.
And
that's what it's.
What's that? And you heard my questions to Mr. Johnson, but what does modify mean in this context?
Well, of the menu of options that were available to the Highway Patrol, it was do nothing, reprimand, suspend for up to 30 days, or terminate. And so their menu of options to modify the discipline was to, well, if termination is not appropriate, then the most that can happen is a 30-day suspension without pay. And they didn't find that was appropriate either. And it is not a boundless, go make up your own remedy of authorization. All of this has to be within the framework of the Civil Service Act itself. And when the Civil Service Act says the appointing authority has these options and no more, those are the options available to Civil Service Board as well.
So them choosing to exercise a 1-year suspension, does that make their decision arbitrary?
It does. And I am asking for a remand to send it back and say, leave the termination in place, because a decision that anything other than termination is eminently unreasonable. That's what I'm asking. That's what I asked for in front of the district court. That's what I'm asking for from this court as well. Why? Because Judge Bruns, getting back to your question, if they could fashion anything they want for this case, one of the appropriate things would be, well, we're going to discipline you and make sure that you can never drive a car again and do this to someone else. That's problematic in that that's not one of the menu of options. He's in the classified civil service. At that time, he was a trooper, so there's no non-trooper position to reassign him to. So reassigning him to a position where he can't kill somebody it would be what we're trying to accomplish. Well, we can accomplish that by telling him, you come on shift, you do 5,000 push-ups, and if you can still lift your arms after that, then maybe you can go patrol the highways or something. In other words, do it so it's impossible for him to kill somebody. That's not a menu. That's not a reasonable option either. So the options that were available for the Civil Service Board to modify the punishment is to remove it from a termination down to a 30-day suspension. And they clearly said that that wasn't enough.
They found something in between. It does seem like that, in addition to what Judge Warner indicated, that the board was concerned with what they call an unusual way in which the review was handled internally. And it was a little unusual in that some of the supervisors went back and modified the reports. And they also seemed to put some weight on the fact that he did not lose his law enforcement certification, and that the Shawnee County District Attorney had not filed charges against him. Are those things enough to support their decision? The termination was unreasonable?
Short answer, no.
And why? I figured you'd say no. If you said yes, we're done.
So the longer part of that, the fact that another agency does not decide to press charges, the fact of the matter is the KLETC or the C-Post never actually initiated any investigation. So their decision not to take action was not based upon a review of the facts.
What C-Post?
Pardon?
C-Post, what is that?
Kansas Commission on Peace Officer Standards and Training. They're the ones who grant and decertify law enforcement officers.
I thought I had it right, but I just want to make sure.
Too many acronyms.
Right. So yeah. So him saying that C-Post didn't pull my certification. Okay. They didn't open an investigation. They didn't. That's a discretionary function to C-Post. That doesn't mean it's a reason. Well, they certainly didn't bless what he did. The decision of the prosecutor not to charge him with a crime, again, prosecutorial discretion, we don't control that. What we control is whether we're going to give Mr. Dobler another car to go kill somebody else. And at the time those decisions were being made, that was before Judge Pickering made the decision and made the actual finding that it was a Fourth Amendment violation, applied the exclusionary rule. All went up through this court, review denied by the Supreme Court.
Do we even need to get into that? I mean,
Yes.
It was subsequent. It seems like your argument is that that the decision of the Civil Service Board should be reversed regardless of all these additional things that happened after the.
Right. All I'm saying is that Judge Pickering's decision was a flashlight.
It's a Fourth Amendment violation. We deal with Fourth Amendment violations a lot, and we don't terminate every officer that commits a Fourth Amendment violation, nor do we even exclude the evidence.
Not even every
In every case.
violation is the result of killing an innocent.
But that was already in the record. That was already in the record below. We already knew what maneuver he did, where it was at, the trailer park, all of that. Passenger in the car dies. We knew all that. We really don't need all this other stuff, nor do we need to look at it since it was the district court, and we review it as if the appeal was brought to us directly.
I'm still agreeing with you.
Okay.
On that and saying,
well, I'm just wondering why we even need to consider. I'm sure Judge Malone did a nice job, but why consider that opinion?
Didn't the car chase start over a broken windshield?
cracked windshield. That was it.
Or cracked
And he
windshield.
never had more cause other than the fact that they ran from him when he started trying to pull him over. So again, in terms of that gets into the heart of OPS 16, which is when you start a pursuit, you are required by policy to constantly evaluate, one, the decision to start the pursuit, and two, to continue the pursuit and weigh the benefit to the public versus the risk to the public by continuing that pursuit. And here,
Counsel, we keep talking about the facts, and we acknowledge there was a violation. So here's what I keep coming back to is ultimately this standard of review question. What is our standard for determining whether the CSB properly exercised its authority when that review was a reasonableness standard? What is our standard to determine whether that decision was in fact exercised within its appropriate authority?
hard questions by associates. The answer is almost always, what does the rule say? And the rule here is, did the CSB erroneously or interpret or apply the law? Was their decision lacking in substantial evidence, and was the CSB's decision unreasonable? And one, Colonel Jones' decision to terminate Dobler was reasonable. It was not unreasonable. Their conclusion otherwise. And coming back to Judge Bruns's question and the deal about all the facts is the idea that reinstating Justin Dobler is unreasonable because it ignores the enormous dimensions of his admitted behavior, which you say are just the facts. Well, those facts are so significant and so important that any decision other than termination is by definition unreasonable, arbitrary, capricious. That's why I'm asking you to remand it and that with directions to the Civil Service Board to affirm the dismissal.
I do want to follow up, just make sure I understand. If they were going to modify, it's your position that there was a menu of options that they could do, and they just could not create out of whole cloth their own remedy. Is basically okay. And what were those options? Termination and 30-day suspension.
30-day suspension.
Any other options?
Reprimand and do nothing.
Okay.
Any other questions from the panel? All right, thank you, counsel.
Got all mine.
Mr. Johnson, I believe you've got some rebuttal time up here with us.
Judge, I just want to follow up again on the scope of review, which I agree is a difficult question to decide, but the statute, which is 752929 DB, not only uses the term modify, it also says that the board may order any other action it deems appropriate. And as the decision I cited in my brief in the Del Sadio case, this court said that's a very broad grant of power. And so that's what they did in this case, is they decided to modify it and order what they deemed to be appropriate. So then the question becomes, okay, is that
Case, why include a menu of options in the statute?
a menu of options for what?
For potential outcomes for the CSB's decision.
Well, I think those were not limiting ones, but maybe more examples because the power is broad. They can modify or order any other action they deem appropriate. That's pretty broad.
Usually when we hear language like that, we think well, that includes like catch-all, potentially like, equitable relief, it fines, costs, et cetera. Does that mean it appears that your argument is it basically nullifies all of those menu of options. They can do whatever they want.
Well, I would say that my position is they have broad discretion under that decision. So really, did they abuse that discretion? Was their decision so far the mark that no reasonable person would take that? And that would be the standard I think you have to look at, which is a difficult standard to overturn. What the Civil Service Board has done is that they acted unreasonably, meaning that they abused their discretion, that they took a position that no reasonable person would take. And
Is that different from the reasonableness assessment that the Civil Service Board does? Is our assessment as to whether the CSB's decision was reasonable a different assessment from the CSB's decision as to whether the patrol's decision was reasonable?
I would say yes.
Why?
They have broader authority to provide a remedy. This court can only affirm and reverse. They can modify what's been done. They can order something else that was not done, which under the Judicial Review Act, you can't do. So they do have, my position is they do have broader authority than you do when they review the Civil Service Board.
So they have a broader menu of options, but what about the reasonableness determination?
It has to be reasonable. I'm not disputing that their decision, the Civil Service decision, that the agency acted unreasonable has to be a reasonable position. Meaning, is it supported by substantial competent evidence, and would it be within the realm of reasonableness? That reasonable people could disagree, as the board itself did. They disagreed on what it ought to be. And that's my position. Reasonable people can disagree on what this is, but their decision was not so far wide of the mark that no reasonable person would have accepted it.
So what evidence is there in the record from your perspective to support the finding that, quote, termination was unreasonable, close quote?
Well, the Civil Service Board didn't look at the Fourth Amendment, any of those issues, because it wasn't before them, because most of those things didn't.
No, I'm saying what evidence is in the record before them to support their finding that termination was unreasonable?
Well, they looked at the policy of the internal policy of the Highway Patrol, and they said, considering all the policy, all the factors listed in that policy, based upon the evidence we heard, we think that that was unreasonable. And they went through, as I outlined in my brief, they went through 4 different categories in analyzing why they thought the Highway Patrol had acted unreasonably and why they thought their own decision to modify or have a different decision was a more reasonable position. And I see I've used my time. Thank you very much.
Thank you.
This was, as I have indicated, a very interesting case. The court takes the matter under advisement, and I want to thank counsel for your excellent briefs and for your discussion here today. We'll issue an opinion just as soon as we're able,